party defense is important because sometimes it's not the person that's there standing as the defendant that might have committed that crime, and there's evidence to prove that. That's why that defense is offered. It's not supposed to be offered to make up false allegations against innocents.
Matt, did you ever, at any point in your life, ever consider becoming a lawyer? Did that ever intrigue you at all?
I thought about it. The problem is that you only make money when you do the scumbag side of things.
Yeah, good answer.
The prosecution,
Good answer,
you can't make money from the government. So it's like you're trapped in that, or you go to the dark side. And I think that's the problem.
Yeah. No, that's a good answer because I'm seeing that now too. Not that I ever applied to law school or anything like that, but just going back to my impressionable high school self. Yeah, sometimes the thing about ethical lines is they're not in anything. There's a reason ethics has widely been talked about since the time of the ancient Greeks. It's not always clear to know where the line is, and it's not when you're trying to come up with a system of rules. No rule is going to fit every situation. So was it ethical for David Yannetti to just take a young college girl like Allie McCabe, who hasn't done anything wrong, and try to imply what he did on the stand, that she was part of some murder conspiracy, shuffling Colin Albert all around town after he allegedly took part in this murder? He knows that that's wrong. He knew that he was misinterpreting that data. He knew that. Is that, I could not do that, but I guess
You cannot talk. You have morals. The host admits you to the meeting.
Yeah. Do defense attorneys lose these morals over time, maybe?
That's what I think. I think they come out of law school often and they're just like everybody. They're idealists and they want to get people who are falsely accused off. I'm talking about people who go into defense work and they want to do the right thing, and somehow the whole line gets muddled.
Right.
Yeah, I mean, I feel like a lot of defense attorneys say, it's not that often where there's really a wrongly accused person, but it's their job to, limit their exposure to the punishment, I guess. Which I guess that's true. I think there is ethics, though. I don't think this defense is ethical at all. I think it goes way over the line, and these attorneys should be held accountable.
I know that Jen cut.
Oh, so I just wanted to say. Go ahead.
You are unmuted. Can everyone hear me?
I know you've covered the Delphi murders extensively, and so the elaborate theory about the Odinist cult put out by the defense counsel, and they included a lot of people, specific names of people in that theory too.
We hear a big echo.
Correct.
I think two people.
I never supported the Odinist fiasco. I always believed they should have gone in the realm of Ron Logan, where they had actual evidence gathered by the FBI. There was a probable cause affidavit to support that, and hours and months of investigation by the FBI to support those allegations. That made a lot of sense. Also, the Keegan Klein aspect, also the aspect regarding the the jail informant information that was provided. That was my issue with that. A wild case. It wasn't just rumors and things. But back to this, I was just going to comment on the defense attorneys. For 28 years, I worked with defense attorneys, and now as an expert, I work with defense attorneys. That's what I do. And there are so many, the lion's share, 90% are amazing people with ethics. I mean, that's what's so sad is we're seeing on television in this high profile case, the dregs. This isn't what it's really like out there. Normally, these defense attorneys are really good people trying to do the right thing and the best they can. So that's what's kind of sad here.
Matt, are you offended that Aiden and his lawyers didn't name you in their motion?
I was reading that and I was like, oh, good. Well, I mean, I never really directly talk to anybody. I feel like that's just, I don't have the time really to collect the information. So I will read the court documents and, I do talk to people here and there, but I don't try to gather information. I don't think I'm a journalist. I don't think that I can have the time to even deal with that.
Right.
Like people do tell me things and I'm like, is that rumor? Like, I don't have the time to vet it.
Yeah.
Like,
Right.
You know, I just don't repeat it. Like, I'm just like, I have no idea. And I wait to see what you guys say because I know that you guys are the ones that like are digging into everything.
And I'm not actually either. I still kind of cringe when if I use the word source, I feel like I think we might be about to come on, but we'll see. If I use the word source, I'm like, I'm not. It makes me feel uncomfortable, like a kid trying to put on his dad's clothes or something, you know, like a kid putting on his dad's police officer's uniform or something. It doesn't fit. I don't reach out to anybody. Whatever sources I have, they've reached out to me, and so I just do the best that I can to deal with it honorably. I try not to be a breaking news kind of person. I'd rather see it out there first before I report it, you know?
And 23313, the Commonwealth versus Karen Reed, and separately the Commonwealth versus Aiden Kearney. Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please. Sure. I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay.
Thank you.
And do you have the Zoom identification link for me, please?
I do. It's right here.
Thank you.
There's no passcode.
Thank you. Okay, Mr. Clerk, you may
Judge,
call the
thank
case
you.
and identify the parties.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm the special prosecutor on the Aiden Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aiden Kearney. I see him on the Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Kearney. Good morning, Your Honor.
Good morning, Attorney Federer.
And good morning, Judge. Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so. Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged. So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that one, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So my order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Brennan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Sure. May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other?
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorneys, Mr. Brado and Mr. Betterow.
Okay, well, we all agreed, counsel, that those in fact would be privileged communications without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy to Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges, so we would contend that does not fall under the umbrella. After more questions by the court, Mr. Bradel answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Betterow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Betterow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date, but those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823, when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there,
Nothing
Attorney
about
Bradel, because you raised an excellent point, and that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we are privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Kearney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Kearney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified and supposedly acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank you.
So the fact that
Attorney Breda, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney concerning those three areas of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Brado. So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not, this is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I am tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Cannoni specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibits, Judge, these outside people are receiving information that in no way would a prosecution team ever share outside of anything ethically share anyway, any such information. And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that. And we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C. And so we're asking for another step to just really put a fine point on it, that these 3 people must stay away. And a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Little, Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that we generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I'd ask you, how soon do you believe the Commonwealth can reproduce the records in question per my order that are called for by the Rule 17 motion?
Well, I would say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday, and if you encounter any difficulty or challenges in doing that, just please let the court know, and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There has been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact, even though I do not think I had to, that's why I filed the Rule 17, so there is a clear public record that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now. Thank you, counsel.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Goodbye.
Court is now in recess.
Speak to Mr. Brennan.
You can find me either here or in the criminal clerk's office, probably here.
Okay, I'll check both places.
Thanks.
I will hush.
Thanks, bro.
But I thought sunlight was the
So
best
Jen, I guess they want
disinfectant.
to. I guess they want to get a gag order on me, Kate, and Jen. Well, that's fine with me. I don't know. I mean, if they just want a gag order for me from talking about material from this case, it doesn't even affect me. I don't, I'm talking material from Aiden's phones. I have no idea what's on Aiden's phones except what was just in the document presented by the state this morning or yesterday. So, Jen,
I didn't understand it that way. I thought he said they wanted to put the belt on the suspenders, and right now the people named that are gagged are the attorneys and the individuals that are officers of the court in those cases. I don't think there's any mention of you, me, or anybody else being gagged. That would be so far out afield from First Amendment. It's just no way would he do that. I think they're just saying, hey, listen, in this case also, we want a gag order. I think that's what we're doing. That's how I interpreted it.
Okay. Sounds good. So it doesn't sound like they're going to get the attorney, the messages between Aiden and Karen's lawyers. Did I misread that?
Unfortunately, yes, I think that is accurate, but that's because it wasn't in the original motion. I think, Brennan could file something else that says, now that I don't know if you can say now that we know, but that was kind of the judge's position.
Right.
It's such a area that is really taboo for judges and attorneys alike. They do not want to meddle in the attorney-client privilege for obvious reasons. And, we ran into issues like this all the time where you had attorneys that were bad, particularly in cases involving the Cali cartel, the Medellin cartel, where they would hire one attorney's firm to represent everybody, and it was all really just a gaggle and a mess of immorality that was going on. But they still wanted to be careful. In other words, money laundering and things like that were going on, and it's a very fine line when you have for the ability to see when an attorney is acting illegally in their communications and in their actions with their client. It's so difficult to get there. And this judge seems to be, and so is Canoni, right? They don't want to bridge that line.
Right. So we're done for today in terms of hearings, right? Is there anything else coming on as far as you guys know?
I don't think so.
They're still showing on Boston Fox 25 soon Karen Reed due in court for final pretrial hearing. But I don't think there's anything else coming up. Well, let me just turn my mic off. I'm getting a call from someone that might give me.
Great.
That's
Matt,
Hank Brennan.
Forward to your. Oh, that's funny. That's what I was going to say. I always look forward to your parodies and jokes about the case. So keep them coming. Keeps us all laughing.
This is a circus.
I have, just to interrupt real quickly, I have a call from my doctors. So I'm going to leave you guys on and I'm going to go and take this call.
Okay.
I thought it was very interesting at the end. Tell me if you had this reflection that Brennan got in the last word and he made it very clear he wanted the gag order. The CW was tired of all the leaks of information that happened on the defense side. And this was his order that he asked Canoni to, support. And she did. And there's been no leaks on the CW side. It's so absurd. And in any event, I just thought it was great. And then you could see Bradel wanting to come in and sort of counterpunch, and the judge
Yeah, I mean, that was good. And I think there has been no leaks because we'd be hearing about the Lexus tech stream. We'd be hearing all kinds of stuff, I'm sure. And we haven't heard anything. But I think Turtle Boy is worried about, because he is in the business of bashing people, and he's afraid that, with his data that he can be bashed all over the place, because I'm sure he's talking out of both sides of his mouths to a lot of people. And he's afraid that's going to be exposed.
Well,
that's what it's all about.
I think the big thing is too, and I agree with that, but in regard to his counter accusations, if he just would do his own research, and if he would look at different court filings coming out, if he would actually sleuth instead of just being a propaganda minister, he would probably be surprised. Remember, this case has been spoon-fed to him by Karen Reed. He hasn't had to sleuth. Anytime your phone's ringing off the hook telling you, hey, this is what's coming up. Here's a terrible picture of John O'Keefe to show, right? Here's this. He hasn't had to do any work. He's been spoon-fed. The rest of us in the sleuthing world are out there looking at court documents and reading what we can get our hands on this case. And so really, we're just better sleuths of what is an open source category than he is. And he's mad. And, it's just interesting to me.
Yeah, for sure.
I do think it was a little bit interesting. It was also a little bit of a challenge for the state here to show. There was obviously the original order on March 20th, and the judge was maybe reluctant to overturn that based on that misunderstanding. But Bradel does make a relevant point here that is this. I mean, it's a little bit of a reach, this getting these communications between Turtle Boy and Karen's attorneys, how that goes to consciousness of guilt. It would have been great if we got them, but it is a little bit of a stretch as to whether that actually is relevant.
Well, to me, I think it absolutely is, because if I was accused of a crime and there was evidence and I knew that I was innocent, the last person I would want representing me is Turtle Boy. So the fact that her attorneys are, talking to him, feeding him information, congratulating him about his, trash campaign, that is consciousness of guilt, because I would put a cease and desist on him. I would be like, you do not talk about my case at all. I do not want those people showing up. I don't want them harassing families. And they did the exact opposite. So I feel like that is very clearly consciousness of guilt, in my opinion.
I think of it from another angle. I agree with what you said, but from another more direct angle, if she is talking to him, trying to set up these witnesses to be harassed, providing information and inside details, I think that shows consciousness of guilt, because it shows a furtive effort on her part to direct away from the evidence of her guilt. And that's because she knows she's guilty. So that's how
I got a new motion here. Thank you. You guys will be interested in this. Thank you, Kim. You guys know Kim Fair is always on top of this stuff. So this is a motion to exclude the ARCCA guys. So
basis, or you probably haven't had a chance to look.
Yeah, it's very short, but I'm going to. It's because I'm sure it's going to be because of the Rule 14 discovery stuff. Basically the communications to the feds. All right. Yeah. So it says the Commonwealth has repeatedly informed the defense and the court that it believes Rule 14 in court-ordered discovery has not been satisfied. Attorney Yannetti disclosed to the court that he had received a subpoena for the U.S. Attorney's Office to produce his entire case file. The Commonwealth was unaware of this information. Additionally, the Commonwealth has no idea what Attorney Yannetti provided to the U.S. Attorney's Office, nor does the Commonwealth know what was provided to ARCCA experts, other than more than what is listed in the Group ARCCA report. After court on March 25th, the defense disclosed that the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. So, yeah, that's interesting, because that implies they're still sending him stuff even though the investigation is closed. I don't know. The Commonwealth now understands that the defense had or has been providing all discovery to the U.S. Attorney's Office in an ongoing manner, all material outlined in the Commonwealth's notice of discovery. This is the last line. On March 25th, the Commonwealth learned that the defense may ask ARCCA to engage in further review, analysis, and testing, which could result in further discovery. So that was the last line. So defense may ask ARCCA, so they may be sending him new material, which they would, right? But now they're not working for the U.S. Attorney's Office; they're working for the defense.
So what's changed? I mean, that's interesting, because I feel like she already ruled on this, and he's bringing up these new points from March 25th. But do we even have any more hearings before they start? Well, I guess they could have the hearings while they're selecting the jury.
Oh, there were a couple more lines on this that I didn't see. All right. Discovery deadlines have passed. The Commonwealth will not be able to fairly prepare its expert witnesses for new materials, testing, or opinions. So, yeah, if the defense sends ARCCA new stuff and they do new tests and come out with new reports, this doesn't give the state time to prepare for those. The Commonwealth will not be able to prepare for new opinions beyond previously provided report. The Commonwealth cannot adequately prepare for trial without all court-ordered and Rule 14 discovery. So
I think the problem is that Judge Cannoni set a precedent for this in the first trial. With this exact same situation concerning their dog bite expert, right?
Yeah.
Remember when they brought her on, and they argued this exact same thing. Rule 14, this is unfair. We didn't have discovery. We weren't able to. And then they had the voir dire. But remember, she allowed her to testify, even though there were these exact same concerns. So she might have set a precedent in this case that she's going to let them testify. ARCCA meaning,
Right.
even though there's a routine violation.
So if she were to exclude ARCCA, I know none of us are lawyers. If she were to exclude ARCCA at this late point, that handicaps the defense. Like if that's their only evidence. So would that potentially force the judge to postpone things? Would that be and which we know she's not going to do? So would that be a factor in her decision?
I don't think. First of all, she's going to let ARCCA testify.
Yeah,
that's what I think. I think he's got it on the record, but the ARCCA is going to be able to testify in large part for what you just said.
Yeah, I definitely think they're going to be testifying. I think with the dog bite lady, she did say she let her come in, but she was like, Lally, you can have a rebuttal witness. How long do you need? And he never had got one. And I think he said a week. So Hank Brennan's going to be able to pull someone, but it is going to be like a struggle to get someone to review everything that they said. It's probably going to be the same guy, I would think. They'll just have Welcher come back and rebut everything that they said, I would think. But
yeah,
I mean, it is going to be a struggle because if he has to travel, or I don't even know if he's local. Commonwealth has a budget. The defense doesn't. The defense has money pouring in. So, you know.
That all goes into the Omni, though.
Right. The defense having all this money pouring in, they couldn't get a legitimate expert that's not biased, that's not been caught lying. Like, it's unbelievable. Like, all these people are giving them money. Like skipping meals to give them money, and they can't even get a legitimate expert.
So they'll probably, I think they already scheduled it. Didn't they already discuss having a voir dire of the ARCCA guys, another voir dire, Jen?
Yes.
Okay. All right. Yeah.
That's so critical. It really is. And then when I say critical, who knows what we're going to discover if they are honest on the stand, which I don't know if they have the ability to be honest. I mean, once you taint yourself and you're not honest, and Wolf wasn't honest already on the stand. Remember, he was asked direct questions about conversations with the defense. Isn't this the first time you've ever spoken? You know, he just a litany of untruths on the stand. To me, if this were in federal court, he would already be kicked out. It's a brainer. He'd be out for, really perjuring himself. And can you imagine in that this is what they do for a living. They testify for a living, and they've been so tainted because of this case. Geez, I keep wondering what they're thinking as experts. If I were in their shoes, I wouldn't want anything to do with this case. I'd say I'm done.
Right. Mm-hmm. I think that Hank might be trying to push up the voir dire to come sooner. And I think that's probably what his intention is with this motion, is get them on the stand. Because that is going to be a good voir dire. Because what are they going to say? They either have to say I was directed to look at throwing the glass in the car, or I'm an idiot and I just ignored half of the damage on the car and decided to shoot it with a potato cannon. There's so many things that how are they going to weasel out of? It's going to be very interesting.
Kim just sent me another document on this. So looks like this is short enough to go over quickly. Notice of reciprocal discovery. I don't see the date on this. This is from Karen, though. So the defendant hereby submits the following notice of reciprocal discovery regarding ARCCA. The defendant.
Yeah, they're putting it in, right?
Okay. A complete statement of all opinions. Oh, so all right, I got you. Yeah. So a complete statement of all opinions to be expressed by Dr. Wolf and Andrew Rentschler and the basis for their reasons. This information is in the possession and custody and control of the defense, has already been produced and can be found in the ARCCA report, voir dire testimony, and the trial testimony. So they haven't changed anything. And this is the problem, right, with people's integrity and with expert witnesses. Even though they now have the text stream data, and I'm not even talking about the updated text stream data. I'm just talking about the text stream data from last year that they didn't have that showed Karen going in reverse at 24 miles an hour. They're not going to change their opinion. They're locked into their position, and that's that. And I don't think anything short of video showing Karen strike John would change it. No. So let's see. Request 2. All notes, reports, and materials relied upon either witnesses for reviewing the specific case. All materials reviewed by Dr. Wolf, Dr. Rensler. Copy of all materials provided to ARCCA. A copy of the grand jury subpoena issued by the United States Attorney's Office to Yannetti, dated November 22nd, 2022, demanding production of all materials produced in discovery to date by the Commonwealth. Of course, the text stream data came long after that, but that was. But as David Yannetti said, it was an ongoing subpoena.
It's not an ongoing subpoena once you testify or once you submit the documents. It's done.
But what I mean is that so they got all the evidence in as of November of 2022. However, once that text stream data was available, they would have had to send that too, ongoing in that regard, right?
You mean to the grand jury?
To the feds, to the U.S. attorney. Yeah, it's a. I'm sorry, you're correct. It's a grand jury subpoena, so you're correct. Yeah.
So not if the grand jury is no longer convening regarding the matter. I think people are so confused about how grand juries really work. And there becomes a time always when they stop investigating a case, or it goes to true bill or no bill decision making. And then often it's just tabled and it's no longer under investigation by that grand jury. I think that's where we're at, the latter of what I just said with this particular grand jury. So if they're no longer investigating it, it would make no sense that they would still be providing information to the grand jury.
All right, so look at this here. On October 22nd, this past October, the defense provided the U.S. Attorney's Office with discovery. So they were still giving discovery material this past October relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information in turn to the ARCCA experts. The defense's understanding is that this information was not provided to ARCCA. Now, the contract with ARCCA ended last July.
Well, the U.S. Attorney's Office and the DOJ, in my view, once they produced that 3,000 plus page document to all parties involved, they absolved, they were compliant with TUI, and they washed their hands of this. That's how I interpret this. There's no charges you could see in those 3,000 plus documents. There was no illegal activities done by the individuals involved in this. There's no cover up. There was nothing except for, what we know about Proctor, making the statements he made and so forth, which is not public corruption. It might be a foul mouth, and it might not have been prudent, certainly, to talk like that and to talk to people not involved in the investigation. And those are violations, but they are internal violations. They're code and ethical violations. They are not public corruption per se.
But all right. So in October, the defense provided the U.S. Attorney's Office discovery relating to the vehicle reconstruction. Now, that tells me, and you guys jump in if you think I'm wrong, that because it was treated as an ongoing subpoena, they were going to continue to give any discovery material that they had to the U.S. Attorney's Office, which that means is that when they did get the text stream data, whenever they got it, so let's say they seem to have got this late. So the defense probably got this in January of 2024, so last year, just several months before the trial, maybe even early February. I forget what the date was. But they would have sent this to the U.S. Attorney's Office. Now, the ARCCA guys, what's that? Good. So the ARCCA guys testified.
Done.
What's that?
Go ahead. Sorry.
The ARCCA guys testified that they were not ever sent the tech stream data. So what this tells us is that presumably the defense team was sending everything they got when they got it to comply with that subpoena to the U.S. Attorney's Office. And so that means they would have sent the U.S. Attorney's Office the tech stream data, but the U.S. Attorney's Office did not send it to ARCCA.
And why would they? The contract was over, correct?
No, but what I'm saying is if, all right.
I know what you're saying, Kevin. This is
they would have no, because they would have sent this tech stream data to ARCCA when they got it. So let me back up. Let's say the defense got the tech stream data in the first week of February of 2024. So last year. So a few months before the trial. They would have, to comply with the federal subpoena, they would have forwarded that to the U.S. Attorney's Office. And so and the U.S. Attorney's Office should have forwarded that to ARCCA before the trial. And they did not. That's what I'm saying.
They would have never, and I'll tell you why. Whenever a federal entity hires an expert witness, every single communication, every phone call, text message, mailing, all of that, they're going to get charged hundreds of dollars potentially. See what I mean? And so the U.S. Attorney's Office wasn't engaging ARCCA at that point. They'd already gotten their report, which they probably paid tens of thousands of dollars for. I mean, we saw $21,000 just to come up for a day and testify. So that report was literally worth, I don't know, I haven't seen the bill. I could probably put together the hours based on it, but literally probably $50,000, $60,000, $70,000 would be the cost of that report. After that, the U.S. Attorney's Office had no dog in the fight. They had already washed themselves of the case. Do you know what I mean? So if
I don't. Yeah, go ahead. I don't agree with this, but yeah,
had to pay for them to then.
I mean, this is back in the spring, in the late winter of last year, as you're coming up to the trial, and the U.S. Attorney's Office under Josh Levy kept this case as open all the way until he left office. So they had a dog in the hunt. They were embarrassed about what happened here. So to the extent that they could have helped the defense of Karen Read, they had a dog in it. They wanted that. I think there's substantial evidence for that. And so I find it now you're saying that they wouldn't have sent this information before the trial, forwarded it to ARCCA because it would have incurred more expense.
And they wouldn't pay anything with. That's what I've said from the beginning last year. I said, anybody who thinks that the U.S. Attorney's Office is paying for ARCCA to testify on behalf of Karen Read in the Commonwealth's case does not understand the process. It's 1,000%. They were working for the defense and being paid by the defense. This U.S. Attorney's Office had absolutely no standing and no dog in the hunt. No, they were done with it by then. Once they gave over.
There's no evidence of that. They were still communicating with ARCCA. They were still communicating, with the defense. So, and I don't know if they didn't
gives them information doesn't mean they were asking for it. I mean, the defense can say whatever they want. They could say, well, we still thought we were under this subpoena. And so we, sent everything to them because they want to absolve themselves. But who they should have sent it to was to ARCCA directly. That's who they should have.
At that time, they didn't know of ARCCA until they got at least unless they're lying, they didn't know of ARCCA until they got the federal stash of papers. That came through the TUI process.
But I'm just meaning they knew by the time trial was getting ready to start.
By trial, right?
Yeah.
Well, but I can understand why the defense team didn't want ARCCA to have the text stream because that's ultimately what condemns Karen is that text stream data. So why would they want ARCCA to have it? Of course not. But if the U.S. Office is going to pretend to be a neutral player here, they should be sending that data to ARCCA, and they don't even have to necessarily request a new report. They're just knowing that ARCCA is going to testify in this case. You send in the data.
That isn't how it works, though, Kevin. when you don't have an ongoing case or a matter that you've got an expert that you're employing, you would never do that. There's no money that's going to be there, thousands of dollars for them to then look at what you send them, the money it costs to send it to them. No, that just would not happen. I know what you're saying. You're saying as a matter of the right thing to do, should they, but no, it's the defense that should have sent it to them, because any decent defense attorney is going to want an answer from their experts that is proper, that has everything involved so they can make a good expert opinion. And to me, that's exactly what we've all pointed out happened here. ARCCA's opinion is it's half baked because it's based on half the facts.
I mean, this is a U.S. Attorney's office where the U.S. Attorney himself took the unprecedented, unheard of step of grilling the witnesses. So, and as I've always said, using TB Daily News as a prop. So, this is not, I think I don't think it's an accurate portrayal. I'm not saying you're saying this, but for people to get the sense that they're just doing due diligence and running an investigation to see if there was something shady here, and it wasn't something that they had a huge interest in. No, they had a tremendous interest in this case, maybe more interest in this case than any other case we've ever heard of, because the U.S. Attorney himself went down and questioned and grilled the witnesses. So they had a huge interest in this case, and they had to be following it very closely. That's why I just believe it's shady that they didn't send over that text stream data. So, but
what I'm
I know
saying, I agree with you. The U.S. Attorney's Office had a dog in the hunt when they had a grand jury that was reviewing materials, and they were interviewing all the Reed witnesses because they were led to believe that there was predication, that there was public corruption in this case. That's their only avenue to investigate. You have to have a federal jurisdiction to investigate. And certainly Karen Reed or John O'Keefe being hit by a car is not federal jurisdiction in this case. They were able to establish federal jurisdiction in the Sandra Birchmore case because they considered her a witness, and they said a witness had been murdered. And that's the only reason. That's why the unborn baby isn't part of that murder charges. Everybody's asking, why weren't they both? Because the federal government doesn't have any authority or jurisdiction there. In this case, in the Karen Reed case, I agree with you. They thought there was going to be, based on what was told to them by this defense attorney's team, probably by Turtle Boy and others, that there was corruption. And then they spend all this time looking, and they come up with the big fat goose egg 0. And that's sort of the end, Kevin, from where they're not going to pay any more money. They're not going to spend any more resources, and they're going to just walk away, which happens a lot in grand jury investigations where there's nothing there, and you move on to the next thing. That's all I'm saying. They had moved on, in my opinion.
Right. So, and I guess here too, there's the motion by the state to preclude reference to and redact the manner of death contained on the victim's death certificate. That's been denied by the judge.
Yeah, because last time it came in.
Right. Because it's explained. I understand why the state wants it out, but I think, they're able to explain to the jury what it meant and what it didn't mean. And so best to let the jury decide. I think that's probably predictable. Yeah. Oh, okay. So, yeah. And the judge wrote in her denial, she said that the medical examiner will be testifying and can be examined on this case, on this matter. So.
Yeah. And of course, the reason Brennan doesn't want it in is because it gets stamped as an exhibit. And, we saw this in the first trial. Remember, they were deliberating and they said, can we please see this report? One that I can think of right off the bat was the crash investigator for the Commonwealth, right? They said, can we please see this report? And Canoni said no. And it's because after weeks and weeks of listening to all this, the jurors forget. And so what they'll remember is what's in a report. And now they're going to be able to say, oh, undetermined, which is little made a very decent argument. I thought that, at the crux of these investigations are these ME's decisions. And when you tell me an ME can't even figure out whether it's a homicide or not, that's a problem. So I see why the prosecution hates that being there.
Well, because I think it's confusing to the jury, because the thing is when the medical, there's a limitation to what a medical examiner can determine, right? So they know that John is dead. They know that the signs of hypothermia, and they know that he had crushed bones in the skull and hemorrhaging in the brain. They don't know which combination of those things specifically caused him to die. Now, the defense tries to exploit that to say, well, maybe he got hit in the back of the head by a baseball bat or something. But that's not what the medical examiner she's saying. She's just saying there's a limitation onto what science can determine here as to what was the most specific cause of death. I don't know. Did I explain that okay? Did that make sense?
Well, I think I agree with you, generally speaking, but I don't think it had to do with the hypothermia versus the getting bashed. I think it had to do with this. She isn't comfortable saying this wasn't an accident. Remember, you can rule something an accident as opposed to homicide.
Right. Good point. Yeah.
Or suicide, that he purposefully walked in front of her car when she was backing up, right? So she's saying, medically speaking, I can't differentiate those three items. That's what the Commonwealth to me needs to focus on. Not that the car didn't cause those injuries, but rather she's not sure under what circumstances that happened. Even though she should be able to, when you think of, because the medical examiner, even though their concentration is on the scientific piece, if you've ever read these big reports, they do their own investigation, really, into what people said, what happened at the scene. They talk to the investigators, and they're supposed to take it all under advisement before rendering a manner determination. But here, I mean, we saw her testify. I've seldom seen anybody more mealy-mouthed than this particular medical examiner.
Right. Yeah, no, she did not help the cause at all. I don't know. She almost seemed to have a little bit of an attitude. It was really kind of odd. But there's limitations to there's limitations to what science can find.
Mm-hmm.
I deal with this all the time. There's limitations to what medicine knows. And that's something that maybe we in the public underestimate. And so when somebody dies and there's no witnesses to it, there's only so much that can be determined from a medical exam. And so John was out. His body temperature was 81 degrees. There was hemorrhaging observed inside a couple of his organs, I think his pancreas and stomach or something like that. And the doctor explained that is a common sign of hypothermia, although she said, we don't know why. Science doesn't know why that's associated with hypothermia. It just is. But other things could cause that hemorrhaging too. So there is a degree of inexactitude here.
Well, that's why they call it a practice. Medicine is not scientific, really. It's, medical doctors, they practice medicine, meaning they, look into things and then they change their opinions. And I tell you, not that I don't have the utmost respect for doctors and people in the medical field, but my sister is a neonatologist, and she will tell you it is merely a practice. We do the best we can. We look in this, that doesn't work out. We look at this other condition and treat for that. To your point, it's not scientific from that regard overall.
Right.
It's based on science, but determinations are practice.
Right. Exactly. It's part art, part science. I mean, that's a little bit like that. It's based on their experience, their instincts, everything they've seen. And this goes into play too when you bring in these expert witnesses too. They're supposed to demonstrate a methodology. And as Alessi tried to point out, this methodology should ideally be tethered to some kind of scientific research or something like that. But that's not always practical. So, is there any, even just in general, let's just say hypothetically, John was attacked by a dog. How much scientific literature is there when looking at wounds, shallow wounds on a cadaver where there were no witnesses to what happened, and those wounds were not fatal or even seriously injurious. So you're going to have, I think you ought to be able to point to certain experts that have relevant experience in their field, but they're not going to be able to point to something in a study that says this is how you can tell if that corpse, if those shallow wounds on that corpse were created by a dog or a taillight. It's just going to be there's limitations to what you're going to get with that tethering, if that makes sense. I make more sense at night.
No, I see what you're saying. I mean, I think the good thing is they took a dog bite mold of Chloe. Remember, the defense doesn't seem to want any part of this because they know that it's not going to line up with those marks because those marks weren't caused by Chloe. But the this go around, the CW is not only going to have their own dog bite expert, they're also going to have the molds, and that the jury can look at it and say, whoa, how could this possibly line up with that?
Right. Right. All right. Well, thank you, Jenny. You're going to be here with us during the trial for as much as you can, or?
I am. I'm planning on streaming every day, and I'm also planning on being a part, definitely as much as I possibly can, about like last year, hopefully. And trying to really stick with the facts. I know it's hard for it's not hard to stick with the facts, but it's hard to ignore the shenanigans that have gone on.
Oh,
And
yeah.
I think particularly for me, I come from a background where none of this is allowed. It's so bizarre for me to see lawyers lie to a judge shake, and then be no sanctions, at least yet. I still think she might be withholding on those.
I agree. Yeah, I think she didn't. It's not like it's a football game where you can throw a 15-yard penalty, right? There's only so much you can do, but you can do some sanctions after the trial. The only real sanction you can do during the trial is to get rid of the pro hoc vice so that you take them off the case. But that's an extreme measure, and the Sixth Amendment really prohibits that, and unless it's really extreme circumstances, and also would have resulted in a lengthy postponement of this trial, which she doesn't want to do. So, I think there'll be some kind of sanctions after the trial. But
I did too. Did you see this message from Trevor?
so why weren't what do you think on that?
Well, what I think on that is, first of all, like if you look at Jim McCabe offered up her phone without any sort of warrant, and I think she did that because she didn't have anything to hide. The only thing she asked to be extracted were her conversations with her girls, because she didn't that's so private, the conversations a mom has with their daughter. And so other than that, so none of those would have been protected because they just gave them up. And what was warrant information, I just don't think there was much fighting going on by these witnesses. They knew they had nothing to hide. They just were open books. And so that's the difference, where you have Karen Reed and the blogger are fighting everything tooth and nail because of what is contained in those text messages.
Right. All right. Well, we're ready to rock and roll. April 1st, April Fools, start of the jury impanelment. I think the process is going to take longer this time. Last time it actually took less than they anticipated, but they're going to have to be much more careful now. Many more people have you seen the jury questionnaire? I
have seen it.
Mm-hmm. Yeah, that's 3 pages, that's pretty long. And there was a lot of specifics in there about how you get, like, how does to each person, how do you get your news? It's not just, have you heard about this case, but how do you, that question, I don't even know how I would answer myself. Like, what's the primary source for me for my news? For many years of my life, it was the newspaper. But, in this online age, I don't, I read online news. So, but I'm not even sure.
Social media, right?
Yeah.
Did you see this question from Tequila? I was thinking, which I love that name, Tequila Mockingbird. I was thinking the brief recap really is that the judge is going to allow the messages still between Turtle Boy and Karen Reed, but anything to do with the attorneys is out, and he wants to make sure it's taken out of the thumb drive that was given to the CW. That's the recap.
Right. Yeah. The state wanted the messages between Turtle Boy and Karen's attorneys. And they were not in the original ruling from March 30th. So this was part of the hearing here, was to get the judge to change that. It was based on a little bit of a misunderstanding between Brennan and the judge, but the judge didn't change it, in part because he felt his ruling was sufficient on March 30th, but also I think in part because Attorney Bradle for Turtle Boy probably successfully to some degree argued that they're not really relevant to consciousness of guilt. And I would say that's probably too. They're just kind of embarrassing to this defense team. It's great in exposing that to the public, but from a strictly legal point of view, they probably aren't super relevant or relevant at all. Maybe. Does that make? Did I sum that up all right? Or
Well, I don't think that that's why he didn't give them over, not because of relevancy, but because of him wanting to breach that attorney-client privilege in any way, shape, or form, not even get into the gray area of it.
Right.
And I think that's it, because those could actually, even more than anything, show consciousness of guilt. But if it's amongst attorneys, he's not going to go there.
But both sides said there was no privilege between Karen's attorneys and Turtle Boy. Even Bradle admitted that.
Right. That's true.
So there was no privilege, but yeah.
Yeah. No, to your point. True.
I don't know, but yeah. So the judge didn't really explain the main. I think it sounded like, hey, I ruled this on March 30th. I'm not ruling again. I'm not going to change my mind. So he sounded a little annoyed at the start of the hearing with Brennan, because Brennan had said they didn't want those messages, or, but it turned out there was a little bit of a misunderstanding on that. Brennan thought that he was talking about messages between Turtle Boy and his attorneys. So, but the judge was very clear. He said, no, what I said was between Karen's attorneys. So, so thank you very much, Tanya. Thank you, Jen, for being here. So we'll get this going again Tuesday. Maybe who knows? Maybe something rolls up before then.
Appreciate
of
your audience. They're so good, and enjoy being with you too, and Matt.
And everybody, this is Jen Coffindaffer from Breaking the Case with Jen Coffindaffer, and we had on Boundless Millennial, or Matt Doherty. And I don't know where Kate was today. Kate was AWOL, but we'll see everybody soon.
All right. Bye.
Thanks, Jen.